Hello, students. Welcome to the paper solving session of झारखंड. जो पेपर आपने अभी दिया है प्रीलिम्स झारखंड 2024. काफी टाइम बाद 2019 के बाद वैकेंसी आई है, बम्पर वैकेंसी आई है एंड आप सभी उसके लिए वेट कर रहे थे. यू हैव वर्कड हार्ड फॉर दिस पेपर. तो जल्दी से ज्वाइन कर लो एंड लेट्स स्टार्ट द सॉल्विंग सेशन एंड एज वेल एज एनालिसिस. आपको आवाज आ रही है मेरी? एम आई प्रॉपरली ऑडिबल टू यू? Just give me a thumbs up or yes in the comment section. Students, am I audible to you? I know you all are traveling back. आप वापस घर जा रहे हो. You have just given the paper. Yes, hi Priya. Thank you for your comment. Priya, how was your exam? Just general feedback. It was easy, it was basic, it was difficult. कैसा था paper? We got few feedbacks from the students on call. मैं उसको भी डिस्कस करूंगा, but let me get your feedbacks. The people who have joined with us. कैसा था पेपर? Jharkhand paper. Okay, Vinita has said moderate to tough. For Priya, it's easy. Okay, we have two feedbacks. The paper is tough, and according to Priya, it's easy. Other people who have joined, please give your feedbacks. I know you have just given the paper, so you want some relaxed time, but there are certain people who want कि मुझे जल्दी से आंसर मिल जाए. What is the expected cutoff which everybody is waiting for? Because vacancy is higher this time, so cutoff depends on the actual participants who attempted the paper and the form of paper, whether the paper is difficult, easy, moderate. So it depends on all these factors. The cutoff is derived from these factors. So हम सारे factors को एक एक करके discuss करेंगे. But let more people join and then we will start. Paper this year, it was expected that yes, Jharkhand Judiciary will be announced, but having 130 vacancies is more than the expected for us. And because of these unexpected vacancies, participants have also increased this year. Yes. Okay. Let's coming to the paper directly. So as per a team, we have solved the paper, and while solving the paper, we get to know that the paper is very basic. It is not that tough. A person who is well versed with the Bear Act, जिसको Bear Act के sections, not even sections, the words of the Bear Act, the title, the language of the section, if that is clear, even if the person who has like learned the section, उसके लिए ये paper बहुत easy था, I can say. उन्होंने the commission has not asked the questions, not framed the questions direct one. Like if they are asking whether this question is related to Article 14, say in option they have not given Article 14. They have given the title of Article 14. So if a person who know that okay, Article 14 is the answer, but a person who knows the title of the Article 14, that is right to equality, then only he or she can able to mark the answer. Yes. We have few more people join. हम उनसे भी फीडबैक ले लेते हैं. कैसा था पेपर आप लोग के लिए? जल्दी से आप लोग बता दो. Then we will start the paper solving first. Then we will discuss the cutoff of the paper. What was the previous year cutoff and what expected cutoff can be go in this year. See, झारखंड का पेपर like in 16 19 we have seen it is a very basic paper. So if a person किसी ने अगर वो पास्ट ईयर पेपर्स, दैट्स व्हाई पास्ट ईयर पेपर का रिलेवेंस बहुत ज्यादा हो जाता है जब आप पास्ट ईयर पेपर सॉल्व कर लेते हो ना, तो यू गेट टू नो व्हाट सॉर्ट ऑफ क्वेश्चन, व्हाट काइंड ऑफ क्वेश्चन इज गोइंग टू आस्क इन द एग्जाम, राइट? तो हमें कुछ वैसे क्वेश्चंस भी मिले हैं, कुछ लेंदी क्वेश्चंस भी इस बार आए हैं। द देयर आर सम पेपर सम क्वेश्चंस व्हिच आर बेस्ड ऑन इलस्ट्रेशन, इलस्ट्रेशंस आर नॉट इजी, एप्लीकेशन बेस्ड क्वेश्चंस आर आल्सो देयर। So reading through that, but 100 questions, 120 minutes, the question is doable because a person has more than 1 minute to solve a question. And without having negative marking is a plus plus point here. Even if you are not sure, you can use the elimination method. You can use which of the best applies to this question. You can mark the answer. So I hope कि आप लोग ने आंसर तो मार्क करा होगा by choosing whichever better, which option is suit better to the question. You people won't have leave the options, right? Priya, Vinita. Yes. Okay. Then we are going to solving the paper first, and we in the meantime you can analyze the paper by solving the paper, and you can get an approximation of marks, what marks actually you have got, and in the last we will discuss the marks which you get and the expected cutoff, right? ओके, चलिए चलते हैं हम अपने पहले क्वेश्चन पे। वी आर सॉल्विंग सेट बी, हम सेट बी कर रहे हैं। सो द स्टूडेंट हु हैव अदर सेट प्लीज मैनेज इट अकॉर्डिंगली, राइट? जस्ट अ मिनट। Yes. So we are doing set B. Let's start, right? So question number one is which of the pehle ke, like the pattern which usually follows that 10 question is coming from English and 10 from GK. This has also followed this year. So आपके जो 20% of the paper is of GK and English, जो last के 3 years 4 years में भी same pattern था। 10 क्वेश्चन आपके इंग्लिश से हैं, 10 क्वेश्चन आपके जीके से हैं, राइट? चलो स्टार्ट करते हैं हम। सो फर्स्ट क्वेश्चन इज विच is the most appropriate indirect form of the following? She said to me, please give me your book. And the correct answer is, would you like to tell me what is the correct answer for this? The correct answer is B, option B. She requested me to give her my book, right? आगे चलें। अगर आपको कहीं पे भी लगता है कि यू हैव डिफरेंट आंसर्स और यू हैव एनी प्रॉब्लम लाइक ये आंसर क्यों होगा, वी विल डेफिनेटली डिस्कस दैट, बट फॉर दैट लेट मी नो इन द कमेंट सेक्शन, ओके? Then question number 2 is choose the word closest to the meaning in the underlined word. The word is darted, a horrible conviction darted through Ramesh, and the correct synonym for the word darted is flicked. Option D is correct. Flicked is the correct answer for question number 2. The synonym of the word darted is flicked. See, these are English questions, so we are not going into very detailed form. We will be discuss law questions in the detail. But English hai, we have to just know what you have marked and what is the correct answer. If both have matched, then we will go to the next question. इसमें डिस्कशन का इतना ज्यादा रिक्वायरमेंट आई डोंट थिंक है. If you can say, we can discuss this as well. But I won't think कि हमें इसमें डिस्कशन के लिए ज्यादा देना पड़ेगा. What do you guys say? Right? Okay, great. Get it. Then question number 3 is what kind of noun that the following sentence has used in the underlined word? The sentence is, I am the girl who has won the gold medal. The underlined word is who, and who is a interrogative or relative pronoun. The correct answer is option C. right? Then question number 4, which among the following is an adverb? Temerity, headlong, precipitation, adventure. And the correct answer is option B. Headlong is an adverb. आगे चले. सी पेपर आप लास्ट ईयर में भी देखोगे, देयर वर एक्टिव पैसिव वॉइस, देयर वर काइंड्स ऑफ प्रोनाउन, देयर वर साइनोनियम, एंटोनियम, वन वर्ड सब्स्टिट्यूशन. सो सारी चीजें वही से ही हैं, कुछ अलग नहीं आया है, कुछ वो नहीं है. द थिंग इज दे हैव चेंज, दे हैव जस्ट इंक्रीज द लेवल ऑफ वोकैबुलरी, आई कैन से. इट इज नॉट इजी वन, राइट? चलिए क्वेश्चन नंबर 5. So choose the word that is different in the meaning of the other words. So the correct answer is option D, that is grinning. Sullen, morose, and gloomy all are synonyms, and grinning is a person who always laugh or who laugh loudly. Sullen, morose, gloomy, like a person who is usually sad or in a morose condition. So these three are synonyms, and grinning is a person who always laugh. So option D is correct. ठीक है. Okay. Moving to question number 6. What is the antonym of the word refreshment? Refreshment का antonym क्या होगा? The correct answer is what you have guys marked. For the antonym of the word refreshment, what you guys have marked? Anyone who wants to answer this question? Antonym of the word refreshment? Okay, the correct word is weariness. The correct answer is weariness. Then, question number 7. To drop in is to. What is the meaning of the phrasal verb to drop in on is? The correct answer is visit. Make a visit to someone unexpectedly or uninvited. To drop in on means to visit someone unexpectedly. Option C is correct. Then correct spelling of the following word. Question number 8. So the correct answer is option A, somnambulist. Option A is correct. Right. Question number 9. Correct sentence from the following. So the correct answer is option A. More than one boy was absent from class. And question number 10. One word substitution. One who always look at the bright side of the thing. The correct answer is option D, optimist. A person who always look at the bright side of the thing is called optimist. So if we see out of 10 question in English, if someone has scored around 7 to 8 is a decent score. हम इसको सब्जेक्ट वाइज भी कैटेगराइज करेंगे बिकॉज द पेपर इज डायरेक्टली 80:20. 80% portion is from law and 20 is from GK and English, and both the portions have a relevant and a vital role for having a cutoff or for crossing the cutoff to you guys, right? So out of 10 questions, 7 to 8 is a decent number. If anyone has scored between 7, if anyone has 7 to 8 questions are correct, then it is a decent marks. Okay, English section is done. Any query till here? Any query till English section? Okay, let's proceed to then GK. GK is also not that tough. It is recently, बहुत recent उन्होंने पूछा था. We were thinking कि 19 में last vacancy आई थी, then they will be asking current affairs from 20 to 24. But they have asked very recent and hot topics which are in news. So let's start with GK. Start करें. Question number 11 is Rohingya refugees has been displaced from which country? And we know that Rohingyas are displaced from Myanmar. It is in news for a quite long period right now. Even today, we have a news update on Rohingyas as well. Then, question number 12. To which of the following country India has export Pinaka multi-rocket system? I hope many of the students will be get confused between Ukraine and Armenia because recently a war-like situation is there in Ukraine. So students might get confused between Ukraine and Armenia, and the correct answer is Armenia. India has exported multi-rocket system to Armenia. आगे चलते हैं. Question number 13. Who won the men's single title in Wimbledon 2023? Wimbledon, we all know, lawn tennis, a big series. Wimbledon is always a hot topic for current affairs in sports matter specifically. So Carlos Alcaraz has won men's single title for Wimbledon 2023. Option A is correct. Then question number 14. Who among the following is the foreign minister of Ukraine? So we have Vladimir Zelensky, we have Dmytro Kuleba, Yenvengi Brzezinski, and Yenvengi Prigozhin. So option A, Zelensky, we all know he is the president of Ukraine. And option B, Dmitry Kuleba is the correct answer. He is the foreign minister of Ukraine. Then question number 15. Again, a very recent issue, Nobel Prize for Literature. So the correct answer is A. Sully Prodamon has won the first Nobel Prize for Literature. Option A is correct. Right. आगे चले अभी 5 questions, not that too difficult, all are related to current affairs only. अगर आपने कोई भी बेसिक सा मैगजीन लिया होगा, कोई भी आप डेली न्यूज करंट अफेयर्स, इवन इन लॉसिको वी हैव डीएनए डेली न्यूज एनालिसिस, अगर आप उसको भी फॉलो कर रहे होगे, सो ऑल दीज you will be aware of all these questions, right? Then question number 16 is, what is the name of organization related to space research in Pakistan? Is it Suparco, it is PASRO, it is ISRO, it is NASA? So ISRO and NASA, these two are Indian. ISRO is the Indian one and NASA is of USA. So these two are eliminated. Option A is correct, that is Suparco. For 16, question number option A is correct. Guys, any issue, any problem till question number 16? In GK, we have seen that out of 10, 8, 7 to 8 correct questions are decent one. Till question numbers 11 to 16 GK, we have seen all these news in current affairs, in hot topics like we have discussed. If you have followed any if you have followed any newspaper regularly, then you will be aware of all these current affairs. Right. So question number 16, option A is correct, that is Suparco. Then question number 17, Vaibhav Taneja has been appointed as a chief financial officer of which MNC? It is Microsoft, Tesla, Google, Facebook. The correct answer is B, Tesla. Option B is correct. Then next is, who was appointed as the caretaker Prime Minister of Pakistan after the resignation of Shahbaz Sharif under constitutional provision? So, like because of constitutional provisions, this is also in news regarding the resignation of Shahbaz Sharif. So, after Shahbaz Sharif, Anwar ul Haq Kakar has been appointed as caretaker Prime Minister of Pakistan. Option A, Anwar ul Haq Kakar. Right. Then next question is, Who is the author of Jinnah, His Successes, Failures, and Role in History? And the correct answer is Ishtiaq Ahmad. Option C. Ishtiaq Ahmad is the author of the book Jinnah, His Successes, Failure, and Role in History. And then question number 20 is which of the following ethnic communities does not belong to Manipur? C. Other current affairs are those for which you have to read the paper. But this question, because the Manipur High Court has involved, Supreme Court has also come into this. Like which of the communities does belong to Manipur? Because violence was there, 144 was incorporated in Manipur after this judgment. So this you must know that Khasi, option D, Khasi community does not belong to Manipur. These communities are in news because of the recent violence in the Manipur, and several cases were also instituted in high courts and in high court and Supreme Court. So every legal person, a person who's related to law, must know about this fact. So we are done with GK section as well. Can I know what marks you are scoring till now? Out of 20, how many questions are correct? Any one of you? Out of 20 questions, how many of you get the correct? In English, we found 10 out of 8 out of 10 questions is a decent score. In GK, I can say 9 out of 10 is a decent score. I can say that the book author might be a difficult question for you because this is something new. But apart from the question number 19, all 9 are doable. So the decent score is 9 out of 10 in GK portion. So we are done with GK, we are done with English. Now coming to law section. चलिए law section पे. Question number 21. In which of the following cases review of a decree or order cannot be allowed to an aggrieved person under the rules of order 47 of the Civil Procedure Code 1908? So where there is a discovery of a new and important matter of evidence or which wait, just a minute guys. Yes, there is a discovery of a new and important matter and evidence which, after the exercise due diligence, was not within his knowledge. So, an option A is pertaining to discovery of new and important matter or evidence. So, we are asked that under this order, which aggrieved person can review a decree or order is not allowed. So, which are the grounds on which review of a decree or order is not allowed? So first ground is when a new and important matter or evidence has been come into the knowledge. Then second is some mistake or an error apparent on the face of the record. Whenever there is a mistake or a error that is apparent on the face of the record. So option D talks about mistake or error apparent on the face. Third is when there is a decision on the question of law on which judgment of the court is based. So, whenever there is an option C talks about a question of law on which the judgment of the court is based, is reversed or modified, or through any changes has been done on that decision. And option D, in all the cases, review of the decree or order can be allowed. So, all these three factors are correct on which a review of a decree or order can be allowed. Hence, option D is correct. Either a new or important matter or evidence has been found, or some mistake or error apparent has to be got, or if any decision has been on which the judgment was based was reversed or modified in subsequent decision, then all these three are grounds for review of a decree or order. Option D is correct. Then question number 22. Evidence may be given of the fact in issue, of relevant fact, of fact in issue and relevant fact, of fact in issue, relevant facts, and of the contested question of law. So evidence may be given to fact in issue and relevant fact. Evidence is given for proving fact in issue and the relevant fact. Option C is correct here. Then question number 23. Which of the following provision of Indian Evidence Act empowers the judge to ask any question that he wishes about relevant fact or irrelevant from the witness of the parties? So section 164, 165, 166, none of the above. The correct answer is section 165 talks about a question which can be asked by judge pertaining to relevant fact or irrelevant from the witness or parties. Question 165 of evidence, section 165 of Evidence Act talks about empowers a judge to ask any question related to relevant fact or irrelevant facts to the parties or to the witness as well. So options B is correct. Then question number 24. In which of the proceeding under CPC the High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies? So correct answer is option C, revision. If you go to the bare reading of revision, the definition of revision, you will find that High Court can call for the record of any case which has been decided by a court subordinate to him, to the High Court, and no appeal lies for that case. So this it is option C, that is revision. See, आप अभी यहाँ पे देख रहे होगे कि the questions are in mixed format. तो झारखंड the only thing where the students might bother, जिनको थोड़ी सी प्रॉब्लम हो सकती है कि क्वेश्चंस मिक्स्ड फॉर्मेट में. अभी आप देख रहे हो कि एक सीपीसी का आया एंड देन अगेन वी हैव इंडियन कॉन्ट्रैक्ट एक्ट 1026 ऑफ आईपीसी. सो थोड़ा सा बैलेंस बनाने के लिए ना आपको यू हैव टू बी वेल वर्स विद द लाइक फैक्ट्स और विद द सब्जेक्ट मैटर ऑफ अ पर्टिकुलर सेक्शन. क्योंकि अगर आपको सब्जेक्ट मैटर नहीं पता होगा ना कि क्या इस डेफिनेशन में है या फिर व्हाट दिस सेक्शन टॉक्स अबाउट, तो थोड़ा सा आपका माइंड डाइवर्ट हो सकता है बिकॉज इन एवरी क्वेश्चन द सब्जेक्ट चेंजेस. सो थोड़ा सा आपको इन डेप्थ नॉलेज होगी ना तभी आप बहुत इजीली मैनेज कर पाओगे बिकॉज द पेपर इज बेसिक. ठीक है, लेट्स मूव टू क्वेश्चन नंबर 25. A singer contracts with B, the manager of a theater, to sing at this theater for 2 nights in every week during the next 2 months, and B engages her and agrees to pay her 100 rupees for each night performance. On 6th night, A willfully absent herself from the theater and B in consequent resigned the contract. Which of the following legal consequences may be followed thereof? तो अगर आपने कॉन्ट्रैक्ट एक्ट पढ़ा है, you may know that this is a direct illustration, and the correct answer is option B, that B must pay A for the 5 nights which she had sung. She can rescind the contract later on, but she will get the pay for the 5 nights which she has sung. So जो illustrations भी आ रहे हैं that are also of direct nature. कुछ भी changes नहीं है उसमें कि बहुत ही modular changes कर रहे हो so that you have to apply your mind more than that. If you are well versed with the like bare language of the section or article, you will easily crack the paper. आगे चलते हैं. ठीक है, अभी तक कोई क्वेश्चन आपको वी हैव डन 1/4 ऑफ द पेपर, दैट इज 25 क्वेश्चन. मे आई नो द स्कोर, व्हाट स्कोर यू गाइस हैव रीच्ड टिल नाउ? We have done till question number 25. We have talked about what is a decent score for GK and current affair for English. We are dealing with law portion now, right? Question number 26. In which of the following offences under IPC previous sanctioned under section 197 of CRPC is required for court to take cognizance of an offence alleged to be committed by judges and public servant? So it is asked for any offence alleged to have been committed under section 354A, B, C and D. Option B is correct. Then question number 27. Section 300 of IPC, how many kinds of exceptions have been stipulated where culpable homicide is not murder? See, they haven't asked what kind of exception, they have asked like how many, and those are number. If they want to make this question tough, तो वो यहाँ पे exceptions को mention कर देते, and then they will ask that which of the exception is not mentioned in section 300. But how many numbers are there? So one can easily answer that there are 5 exceptions in section 300 of IPC. Then question number 28. An aggrieved wife W registers FIR under section 498 and 323 and 406 of IPC against her husband H at the police station of competent jurisdiction. ठीक है. After 2 years since the registration of FIR, an amicable settlement हो जाता है husband और wife के बीच में 2 साल बाद. They are living happily, और वो and they have been living together happily over a year now. At this stage, husband and wife both approach High Court for quashing of FIR under Section 482 of CRPC. However, in the meantime, the police investigation has been completed. Okay. In the meantime, because 2 years has been passed, so the police investigation is completed and charge sheet has been filed against the accused husband. Which of the following is legally permissible? So the High Court cannot quash FIR as offence of which FIR is registered are not compoundable under Section 320 of Criminal. This might be a correct option. Then the High Court cannot quash the FIR first because offences of which FIR is registered are not compoundable. Secondly, because the charge sheet has been filed. Third, the High Court is mandated to quash the FIR as wife, the alleged victim and husband. The alleged accused both are generally requesting to quash the FIR. And fourth, the High Court in its discretion may quash FIR if it's find it will secure the end of justice. See, यहाँ पे 4 options हैं and somehow, up to some extent, they are correct. But now we have to choose which option suits better. So, option C is here because both the accused and the victim choose to settle the case amicably. So, High Court can quash the FIR. Option C is correct for question number 28. आगे चलते हैं. For the purpose of making a contract, question number 29, a person is said to be of sound mind if at the time of making contract he is. So basically यहाँ पे पूछ रहा है कि who are competent to make contract. So option A is capable of understanding it and forming a rational judgment as to effect upon his interest. So option A is correct. A person who has obtained the age of majority, that is 18 years. So this option is also correct. Capable of giving free consent. So option C is also correct. So option D is correct answer. All of the above. For question number 29, option D is correct. That is all of the above. Then landmark case, that is Kedarnath versus State of Bihar, is based on which section of IPC? It is section 124A that talks about sedition. So Kedarnath versus State of Bihar is a landmark case which is based on sedition, that is section 124A of IPC. Landmark था, easy था, आप recall कर सकते थे इसको, and even the sections are far-fetched. आप देखोगे तो sections भी closely mention नहीं है कि you got confused. 304A, 375, so those are distinguished. So आप easily section 124A को mark कर सकते थे. Why I am saying again and again कि आप mark कर सकते थे? Because there is no negative marking. अगर आप एक बहुत ही कैलकुलेटेड सा रीजनेबल गेस भी आप करते हो, सो देयर आर चांसेस मोर देन 70% कि वो सही होगा, बिकॉज यू ऑल हैव वर्कड हार्ड फॉर दिस थिंग, राइट? देन मूविंग टू क्वेश्चन नंबर 31, section 151 of CPC saves the inherent power of the court to make such order as may be necessary to which of the following? C. The question talks about section 151, that is a prominent section. बहुत prominent section है, हम सबने पढ़ा है कि section 151 किसकी बात करता है. But what they have given, they have asked the wordings of the section कि क्या correct wording है जो section 151 में mentioned है. तो अगर if you have not, because आप देखोगे अगर इसके options हम पढ़ लेते हैं एक बार, to ensure the rule of law or to prevent abuse of the process of the court. Second is, ऐसा बात करता है, अगर हमें थोड़ा बहुत याद है, section 151 talks about prevent the abuse of the process of the court. Then for the ends of justice and to ensure rule of law, इसकी भी बात करता है. And then rule of for end, option C is for the ends of the justice and to prevent abuse of the process of the court. कुछ abuse और ends of justice की भी बात होती है. and for the end of justice or to ensure the rule of law or to prevent abuse of the process of the court. सी, अगर आप देखोगे तो यहाँ पे सारे ही ऑप्शन में कहीं ना कुछ हमने ऐसा पढ़ा है जो 151 में हमें रिकॉल हो रहा है, बट दे हैव आस्क्ड द एग्जैक्ट वर्डिंग। तो अगर हम देखेंगे तो 151 में रूल ऑफ लॉ की बात नहीं है, राइट, बट अब्यूज ऑफ द प्रोसेस ऑफ द कोर्ट है। अगर हम देखें तो इट हाफ करेक्ट। देन अगेन एंड्स ऑफ जस्टिस की बात है 151 में, बट रूल ऑफ लॉ की बात नहीं है, सो ऑप्शन बी इज ऑल्सो नॉट करेक्ट। ऑप्शन सी, for the ends of justice and to prevent abuse of process of court. Option C is correct, right? Because rule of law की बात 151 में mention नहीं है। Option C is correct. चलिए आगे चलते हैं अभी। Question number 32. Taylor versus Caldwell is a landmark case on the issue of doctrine of impossibility. ये भी बहुत landmark case है। If you have solved our test series, जो हमने आपको test series provide कराई थी for Jharkhand, these all questions can be easily found there. The test series is tailored in such a way, we have looked for the past year papers, we have looked what sort of question they ask, and what which subject what topic is more dominant in that. So उस test series को हमने in that way we have formed. तो अगर आप ये क्वेश्चंस देखोगे, our team is working on that as well. How many questions are there in test series which are asked in this paper? So I will be releasing that data as well. That will be in the last, but before that we will be solving the paper. तो उसके लिए आप लास्ट तक बने रहो। And till here, question number 32, the answer is C. Any issue, any difficulty while you having? अभी तक किसी भी क्वेश्चन में कोई भी डिफिकल्टी है आपको? You are thinking that you have marked something else and we are discussing some another answer, please let me know. Guys, comment section में आपको बस you have to mention, and meanwhile आप अपने scores भी आप mention like count करते रहना, so in the last I can get what actual number of scores you are getting, that in approximation that is also fine. Okay, then we are moving to question number 33. आगे चलें? Okay. Good faith, as defined under Section 52 of IPC, necessarily involves due care and attention, absence of bad intention, genuine belief, all of the above. The correct answer is due care and attention. Option A is correct. Then question number 34. Hardeep Singh versus State of Punjab is a landmark case on the issue of. I guess आपने हरदीप सिंह का केस पढ़ा होगा, सुना होगा, but the thing is we have remembered section only, that is 319. अभी यहाँ पे 319 सेक्शन तो उन्होंने दिया नहीं है, but what they have given the title of section 139, that is option A. Hence option A is correct. Power to court to proceed against the other person appearing to be guilty of offense. Option A is correct. Then question number 35. The contents of document may be proved by primary evidence, secondary evidence, both, or only primary evidence except in certain cases. So it is option C. It can be proved by both primary evidence and secondary evidence. Right? Then moving to question number 36. Be a broker at Kolkata by the order of A merchant there contracts with C for the purchase of 10 casks of oil for A. Afterwards, A refused to receive the oil and repudiates the contract altogether. Which of the following would be correct legally in the given situation? C may sue B for the damages caused and incurred expenses successfully. C may sue A successfully but not B. B may sue A for repudiation of contract. None of the above is correct. If you have gone through Contract Act, this is a clear-cut illustration of Section 222. And the correct answer is none of the above. Right. So question number 36, correct answer is option D. Then question number 37, provision of plea bargaining. We all know it is added through amendment. So it is option B, that is 21A. Provision of plea bargaining is related to chapter 21A of CRPC. Then question number 38, warrant cases under the criminal procedure code means a case related to the offense punishable with death. It is correct. Imprisonment for fine. It is also correct. Imprisonment for life. I'm so sorry. Then imprisonment for a term exceeding 2 years. All three options are correct. Hence option D is correct. All of the above. अगर आप देखो तो इन्होंने कुछ नहीं करा है. They have just cut down the sections into a certain extent. That death give you option. Option D is imprisoned for life, and option C is imprisonment for term exceeding 2 years. So for that you have gone through the bare section. If you have gone through bare section, अगर अच्छे से आपने reading कर रखी है, then the questions are doable for you. Then question number 39. A sues B for money due to a bond. The execution of bond is admitted, but B says that it was obtained by fraud, which A denies. If no evidence is given on either side, then the facts of the case would remain inconclusive, so the case couldn't be resolved. A would succeed in case. B would succeed in case. Burden of proof of the disputed fact lies both on A and B. And the correct answer is A would succeed in case. Option B is correct. Then question number 40. In which of the following cases reference cannot be made to High Court? So the correct answer is before the hearing of suit. Option A itself is correct. Before the hearing of suit, reference cannot be made to High Court. We are done with question 40. Any problem, tell here students. मैं comment sections भी देख रहा हूँ. Just if you have any problem, just mention it in comment section so we can discuss that in detail. Okay. Then question number 41. Which of the following amounts to criminal conspiracy? An agreement between two or more persons to do cause to be done an illegal act. It is correct. An agreement between two or more persons to do or cause to be done an act which is not illegal. By illegal means this is also a criminal conspiracy. An agreement between two or more persons to do or cause to be done commit an offense. Option C is also correct. Hence option D is the correct answer. All of the above. अगर आप देख रहे हो एक ट्रेंड ये भी आया है कि they are asking the question, but option D, all of the above, is correct in many of the questions. They have not twisted the question in that much that a student will get confused. If you are using a prudent mind, थोड़ा सा आपको बस easily question को समझना है, अच्छे से options को read करना है, and you will be able to give the answer. Then question number 42. Which of the following act is not specified under section 17 of the Indian Contract Act reference to fraud? So section 17 is dealing with fraud. So active concealment of a fact by one having knowledge or belief. So this is an element of fraud. A promise made without any intention of performing it. This is also a fraud. Act of connivance to enter into unlawful agreement. This is not a fraud. Option C is correct. Then 43. If you have gone through our previous paper, that is of Haryana, the same question was there in Haryana as well. See, judiciary के exams होते हैं, अलग-अलग states कराते हैं, but they are somewhat influenced by the paper of other state commission as well. अगर आप हरियाणा में जाओगे, same question is asked and the question is related to estoppel. Section 115 of Indian Evidence Act deals with estoppel. तो आप जब कभी भी किसी भी स्टेट के लिए प्रिपेयर करो ना, सो रिसेंट में जो भी एग्जाम्स हुए, वेदर इट इज ऑफ डिफरेंट स्टेट, बट एक बार आप उसको सॉल्व करो. दैट विल हेल्प यू कि लाइक व्हाट इज the current thing is, because law is very dynamic and many changes are going right now, so commissions are trying to adopt that changes. So if one commission is trying to adopt that changes, so there might be a high possibility कि other commission भी उसको follow करे. और उन्होंने, आप इसमें एक perfect example है. I have seen this question in Haryana paper as well. And same question is here in Jharkhand paper also. Okay. So the correct answer for question number 43 is A. It's talk about estoppel, and section 115 of Evidence Act talks about estoppel. Then question number 44, which of the following cases is landmark case on the issue of privity of contract? So option A is correct, that is Balfour versus Balfour. Then question number 45, who cannot record a statement or confession under section 164 of CRPC? कौन रिकॉर्ड नहीं कर सकता है कन्फेशन 164 में? वेरी प्रॉम्प्टिंग सेक्शन है सीआरपीसी का, 164 कन्फेशन रिकॉर्ड होता है. सो हु कैन रिकॉर्ड कन्फेशन? अ मेट्रोपॉलिटन मजिस्ट्रेट कैन record confession. Judicial magistrate can record the confession. Executive magistrate cannot cannot record the confession or statement. Option C is correct. They have asked who cannot record. Then question number 46, in which of the following cases there may be a presumption to absence of consent in prosecution of rape? And the correct answer is rape as covered under section 376 clause 2. थोड़ा सा in-depth question. This is an in-depth question. Option B is correct. Then Navtesh Singh Johar case. Which of the following is true about Navtesh Singh Johar case? The Supreme Court has struck down section 377. It is correct. Supreme Court affirmed its previous judgment in the Suresh Kaushal case. That is also correct. And Supreme Court found certain part of section 377 IPC violated Article 14, 15, 21 as well as 19 of the Constitution. This is also correct. So option D. अगर आप cases भी देखो, Navtesh Singh Johar, Kedarnath, so these are very landmark one, not very cornered one. जैसे यूपी में आते हैं कि बहुत कॉर्नर केस लॉज आते हैं, तो आपको बहुत इन डेप्थ में जाके केसेस देखने पड़ते हैं. बट द क्वेश्चन, द पैटर्न रिमेन्स द सेम. आप देखो बहुत ही प्रोमिनेंट और बहुत ही लैंडमार्क केसेस पूछ रहे हैं, सो इट इज इजी टू आंसर. And why I'm facing easy? Because the paper is easy, right? Then question number 48, which of the following is correct about CPC? See, अभी यहाँ पे इन्होंने CPC के बारे में पूछा है, and we have 3 and 4 different options. In options we have option A we have 158 section, option B 153 section, option C 163 section, and option D 150 section. So it means कि इन्होंने ऑप्शंस को भी बहुत वार्सिटी दी हुई है, बहुत क्लोज्ड नहीं है. अगर आपको पता है कि इन सीपीसी देयर आर 158 सेक्शन, सो यू वोंट हैव टू रीड द नेक्स्ट वन. ऑप्शन ए इज करेक्ट, आपको आगे पढ़ना ही नहीं है. And even if you are confused in sections, you can go for orders. 51 order, 50 order, 52 order, 49 orders. So you can confirm with the order. अगर आपको section पता है या फिर even you know orders, so then it will be easily categorized, which is the correct option. Option A is correct, that 158 section, 11 parts and 51 orders. Right? आगे चलते हैं. Then question number 49, in a contract of guarantee between the creditor and principal debtor, the surety is not entitled for any consideration. Okay. Entitled for consideration either from the principal debtor or the creditor. Fine. Then option C, content with anything born or promise made for the benefit of principal debtor which is sufficient for consideration of surety. Option C is correct. Question number 49, option C is correct. And question number 50 पे चलते हैं. Rules related to appeal to Supreme Court is found in which order? So the order is 45. Order 45 of the CPC deals with rules pertaining to appeal to the Supreme Court. Option B is correct. We have done with the half of the paper. Any query, students? Any answer which you think that is different and I have asked different, or you have marked different? Any query, any problem till here? Question number 50. Yes, guys, I'm waiting in the comment section. Please mention. Any query till here? Question number 50. Like अभी तक हमने जितना देखा, paper is easy. Even illustrations are directly from Bear Act. That is also not from somewhere it is made. दोज आर डायरेक्टली फ्रॉम बेयर एक्ट, तो आप इजिली उसको रिकॉग्नाइज कर सकते थे, आप उसको आंसर्स कर सकते थे. आगे चलें अभी. क्वेश्चन नंबर 51. ओके. So again, Evidence Act. Which of the following provision of Evidence Act protects disclosure of certain kinds of professional communication? So the correct answer is Section 125 talks about professional communication. Then next, we have read this illustration n number of times. A knows B, Z to be behind bush. B does not know it. A intending to cause or knowing to it likely to cause Z death induces B to fire at the bush. B fires and kills Z. Which of the following is correct? So the correct answer is B may be guilty of no offense, but he has committed the offense of culpable homicide. Option A is correct. Then next, question number 53. In an order in the Ashwin Kumar Upadhyay versus Union of India case, the Supreme Court directed that states and union territories shall ensure immediately as and when any speech or any action taken place which attract offences such as section. So they are asking which particular section has been dealt in the case of Ashwini Kumar Upadhyay versus Union of India. And the correct answer is 153 and A and B, 295A, section 506. All of the above. Ashwin Kumar Upadhyay is the correct case laws. Is the recent case law. So option D is correct. All of the case laws are correct. Right. Then next. Question number 54. In order to convert a proposal into a promise, acceptance must be accompanied by consideration, prompt and expeditious, no, absolute, unqualified, and expressed in some usual and reasonable manner. Option C is correct. Question number 54. Option C is correct. Then question number 55 पे चलते हैं हम. Which of the following courts are excluded from the general power of transfer and withdrawal conferred under section 24 of CPC? तो सेक्शन 24 जिसमें जनरल पावर ऑफ ट्रांसफर दिया हुआ है, तो उसमें कौन सा कोर्ट इंक्लूडेड नहीं है, वेदर इट इज हाई कोर्ट, वेदर इट इज सुप्रीम कोर्ट, डिस्ट्रिक्ट कोर्ट, और नन ऑफ द अबव. सो अगर वी गो, so the correct answer is Supreme Court is not given in section 24. It is mentioned separately. Supreme Court की powers अलग से mentioned है, but in section 24 the powers of high court and district courts are mentioned there. Then question number 56. Which of the following is included in the definition of dishonesty? So आपको dishonesty की आप देखो, what they have just make a twist a word. Intention is given in option A, knowledge is given in option B, and in C they have added some more words. So if you are known about the correct word, then you can mark the answer. The correct answer is option A. Whoever does anything with the intention of causing wrongful gain to one person. So option A is correct. Intention is required for dishonesty. Then next, question number 57. Which of the following provision of CRPC provides for dealing with offense committed outside India? The correct answer is section 188. Deals with the offenses committed outside India. आगे चलते हैं. Again, contract. A continuing guarantee may be revoked by the surety at any time as to future transaction by the notice to creditor and consent of the principal debtor. We know that consent is not required. By the approval of the creditor, by the notice to the creditor and principal debtor, by notice to the creditor. So option D is correct. The notice to the creditor is required. Continuing guarantee may be revoked by the surety at any time as to future transaction by giving notice to the creditor. Then 59, Lalita Kumari, a very landmark judgment in CRPC, is related to which of the following issues? So that is option B, registration of FIR under section 154. Then, question number 60. When in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred as Section 79A of IT Act 2000 is. So, for this, you have to refer Section 45A of Indian Evidence Act, IEA. So it is a relevant fact. The exact wording is given in section 45A. आगे चलते हैं क्वेश्चन नंबर 71 61 सॉरी. Which of the following is not correct about the power of the court to allow amendment of the pleading? So power of the court to allow amendment of the pleading is provided under Rule 17 of Order 5 of the Civil Procedure Code. So this is not correct because amendment can be done Order 6 Rule 17. Here it is mentioned Order 5. See, options are lengthy, but अगर आप उनको ध्यान से पढ़ोगे ना तो बहुत easily आप recognize कर लोगे that which is the correct answer and which is not. The only thing is कि बहुत focused होके आपको options पढ़ने थे. If you have read the options very carefully, you can easily mark the answer. Right. Next. Then again, they are talking about a case law, that is Muhammad Khalid versus State of West Bengal. The Supreme Court stated that we cannot overlook the basic principle which underlies section dash of the Evidence Act. And the correct answer is option D. Section 10 of the Evidence Act cannot be overlooked. Then आगे चलते हैं. Section 190 of CRPC, a magistrate of competent jurisdiction may take cognizance of any offence only upon receiving a complaint of fact which constitutes such offence. ये सही है. Upon police report पे भी ले सकते हैं. Upon his own knowledge that such offence has been committed. So all three options are correct. Option D is correct. All of the above. Magistrate complaint पे भी cognizance ले सकते हैं, police report पे भी ले सकते हैं, and on his own knowledge he can take cognizance. Option D is correct. Then, for the purpose of conclusiveness of foreign judgment, which of the following is presumption that may be displaced under Section 14 of CPC? So, it is option B, that is, it has been pronounced by a court of competent jurisdiction. It can be displaced under Section 14 of CPC. CPC, Section 14 talks about foreign judgment. So, option B is correct. Then, question number 65, McNaughton case, very prominent, very landmark one. So it is related to defense of unsound mind. 65. Answer is A. Then, in which of the following cases a judge record an order of acquittal under section 232 of CRPC? Right. So if he finds that there is no sufficient ground for proceeding of trial, option A is correct. If he finds that there is no evidence that the accused committed the offense, option B is also correct. And if the accused plead not guilty, so all these three options are correct. In the scenario of these three options or these three contents, a judge can record an order of acquittal. Hence, option D is correct. That is all of the above. Right. आगे चलें अभी. 67 पे आते हैं हम. 66 we are done. Then, in the case of State of UP versus Devman Upadhyay, the Supreme Court had considered and upheld the constitution validity of which of the following section? That is section 27. आप देख रहे हो कितने landmark cases they have asked. And not that in brief, they have just about the gist of these cases कि उसमें क्या held हुआ था, कौन सा section mention था. Right? तो बहुत बेसिक सा पेपर था, बहुत इजी था अगर आपने अच्छे से उसको पढ़ा है. यू हैव जस्ट, अगर आपको बहुत ग्लिम्स वाली नॉलेज है ना, थरो नॉलेज नहीं है, देन इट माइट बी डिफिकल्ट फॉर यू. Okay. Then moving forward, during a political function of the ruling dispensation state, there is a firing by police in which several persons are killed. Okay. A FIR has been filed in local police station against the accused policeman, and a commission further headed by a senior police office is set up under the Commission of Inquiry Act to investigate the matter. Even when the investigation in pursuance of FIR is underway, the Inquiry Commission gives a denying report against the accused policeman and recommend strongest criminal action against them. So, which of the following is legally valid course of action as per the follow the report of commission? तो एक पॉलिटिकल फंक्शन हो रहा है, वहां पे कुछ फायरिंग हुई है, FIR has been lodged against those police persons who have done the firing, and then further on एक commission बैठता है, and that commission also asked to register an FIR. So in this scenario, which is a legally valid course of action they are asking. So based on the report of commission, a second FIR is supersession. So to the first FIR may be filed. Okay. Then second option, the report of the inquiry commission will be binding on the investigating officer. So binding word might be a tensed here. So binding cannot be here. So option B is not that correct. Then the report of inquiry commission shall carry a conclusive weightage before conducting a trial. So this is the correct answer, option C. Because report of the inquiry commission can't be binding. It has a conclusive evidence weightage, or it is a weightage that can be proved during the trial of this case. So option C is correct. Then question number 69, an agreement not enforceable by law is void agreement. It can't be voidable, it can't be unlawful, it is void agreement. Then question number 70, Dhulabhai versus State of Madhya Pradesh is a leading case law on. It is regarding principles of exclusion of jurisdiction of civil code. Option B is correct. Then Gurbaksh Singh Sibia versus and others versus State of Punjab is a landmark case on the issue of, हम सबने गुरबख्श सिंह का केस पढ़ा है, and it is pertaining to anticipatory bail, right? But anticipatory bail option, which option suits more to the anticipatory bail? That is option A, when bail may taken in non-bailable offences. Option A is correct. Then which of the following offenses related to religion is the most serious one in the term of the severity? तो यहाँ पे 4 ऑफेंस दिए हुए हैं, आपको बताना है किसमें punishment is higher, right? So the punishment is higher in option B, deliberate and malicious act intended to outrage the religious feeling of any class by insulting its religious and religious belief, and the punishment for this is 3 years. For option A, it is 1 year only. So severe punishment is given under option B only. So for 72, option B is correct. Then question number 73. Evidence under Indian Evidence Act means and includes all statement which court permits or requires to be made before it witness in relation to matter of fact and the inquiry. It is correct. All documents including electronic produced for the inspection of court. This is also correct. So both A and B is the correct option. Then question number 74. A lends a violent horse to B. While B rides the horse, it run away violently. B is thrown off and injured. A is responsible to pay damages to B sustained. Options are only if contract of bailment specifically stipulates payment for such damages, otherwise not. Okay. Because bailment concept will be coming to the picture in this question. Then if A knew about the violent nature of the horse and did not disclose it to B, okay. Whether A knew about the violent nature of the horse or not, if he did not, caution B, okay. In none of the cases as the injury has been caused by the act of force, which is not in control of A when injury was caused. So D is not at all related to this. So we have to choose better option in this. And the correct answer is option B. If A knew about the violent nature of the horse and did not disclose it to B, then he has to pay the damages sustained by B. Then question number 75, the provisions related to transfer of decree for execution is given in section 40 of the CPC. Right. Then question number 76. A intending or knowing himself to be likely to permanently disfigure Z face gives Z a blow which does not disfigure Z face permanently but which causes Z to suffer severely bodily pain for a space of 20 days. Which of the following is correct? Whether it is hurt, it is grievous hurt, it is hurt and grievous hurt both, and it is involuntarily grievous hurt. It is option B, grievous hurt. Right? Then question number 77. Which of the following inter alia is true about release of accused under section 167-69 of the CRPC? So accused may release if upon investigation it appears that there is no sufficient evidence. So if there is like absence of evidence or insufficient evidence is there, option A is talking about that. And then option B is accused may be released if upon an investigation it appears that there is not reasonable. So no reasonable grounds have been produced. Option B is talking about no reasonable ground. A was talking about insufficient evidence. Then option C talks about accused may be released with or without bond to appear, provided if or when required before a magistrate. So all these three options are correct. Option D is correct. Then question number 78. A and B agree that A shall pay B rupees 1000 for which B shall afterward deliver to A either rice or smuggled opium. Which of the following is correct legal incident? Agreement between A and B is void totally. See, here are two elements. One is rice and other is smuggled opium. So rice is fine. उसका हम trade कर सकते हैं. So contract can be made because it is a legal thing. Rice can be a sell or it can be delivered to a person. But smuggled opium is an illegal thing. So agreement cannot become void totally. It is a valid contract to the extent of delivery of rice. Yes, it is somehow correct. It is void agreement as to delivery of opium. This is also somehow correct. Option D is it is valid contract to deliver rice and void agreement as to opium. So see, option D controls both of these things, B and C. So option D is the more suitable option. Hence option D is correct. We are done with question number 20, guys. Any question, any query till here? Come on, guys. Any query till here? Question number 78, we are done. I know paper is quite easy, so you guys might don't have that much issue. But any one of you, because we are solving for all of you, so if any one of you have any confusion in any of the questions or answers, just let us know. Our team is working on the back end to solve your query as well. And if you comment your query in the comment section, so we can discuss it right now. Then question number 79. Under section 203 of CRPC, a magistrate may dismisses a complaint for which of the following reason? Magistrate is of the opinion that there is no sufficient ground of proceeding. Magistrate is of opinion that there is not adequate evidence. Okay, here it's talking about adequate evidence. Here it is talking about insufficient ground. Option C is magistrate conclusively finds that accused is no more alive, and option D in all of the circumstances. So option A is correct. That is no sufficient ground. Right. Then question number 80. The term of the offense of sextortion has been included in the Indian Penal Code by way of a state amendment in respect of which state union territory? So it is Jammu, Kashmir, and Ladakh. Then next, question number 81. The rule that once a matter is finally decided by a court of competent jurisdiction, no party can be permitted to reopen it in subsequent litigation. It is based on estoppel, res judicata, stare decisis. Guys, come on. इतने स्ट्रेट फॉरवर्ड क्वेश्चंस आपको नहीं मिलेंगे यूजुअली. Option is correct. Option is option B. That is res judicata. Further, subsequent litigations are barred on same subject matter. That is the crux of subject res judicata. So correct answer is res judicata. Then question number 82. The appellate court shall dash as conferred and imposed by court on courts of original jurisdiction in respect of suits instituted therein, as per the provision of CPC, which of the following correctly fill the blank. So it is talking about appellate court have the same power, perform as nearly maybe the same duties, have higher power, have the same power, and shall perform as nearly as may the same duties. Option D is correct. ठीक है, आगे चलते हैं. Question number 83. Under Indian Evidence Act, the expression fact in issue means include any fact from which either by itself or in connection with other fact the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding will be, may follow, necessarily follows, in all probability follows, none of the above. So see, this is just a bare section give. So the correct answer is necessary follows. मैं आपको बार बार सिर्फ यही बोल रहा हूं कि if you are well versed with the wordings of the section, not with the section. sections का तो knowledge होना ही चाहिए, but with the wordings of the section as well. Because अगर आपको section पता भी है, you might get confused between may follow and necessary follow. Right? So उसको confirm करने के लिए आपको wordings भी याद होनी चाहिए वहां पे. Okay. आगे चलते हैं. Question number 84. A is plaintiff and B is defendant in a pending suit in respect of suit property situated in Ranchi, where the suit is pending. B transferred the state property to C. Okay, who becomes the transferee of the suit property pendent lite, having notice and knowledge about the pendency of the suit for specific performance and order of injunction. So, which of the following is correct provision of the CPC? So, options are C may pleaded as party to the suit under Rule 3, Order 1. Okay, here you need to know through which section or order a party can be pleaded. C may be pleaded under Rule 8A, Order 1, Rule 10.2, Order 1. C cannot be pleaded as party to the pending suit. However, the transfer of the transfer of the suit property to C can be challenged in another suit. So option D is correct because C cannot be pleaded as a party. Option D is correct. Then 85, the provisions related to general exceptions are given under which of the chapter? So chapter, they're talking about general exceptions, not explanation. Don't get confused between chapter 2 and chapter 4. So chapter 4 is the correct answer. Then question number 86. In the bailment of pledge under the Indian Contract Act, owner is bailer, bailee, surety, none of the above. So the correct answer is bailer. Owner is bailer under bailment of pledge. Then question number 87, judicially noticeable facts. See, in Indian Evidence Act, facts are need to be proved, but there are certain facts which need not to be proved. And judicially noticeable facts, let's suppose the sun rises in the east. So this is something which is correct. So it does not need to be proved. These are scientific facts as well. So there are certain facts which needs not to be proved, and judicially noticeable facts are those. So option A is correct. Right. Then question number 88. Which of the following is included or deemed as complaint under Criminal Procedure Code? So complaint की definition आपको देखनी. An allegation made orally in or in writing to the magistrate with a view to his taking actions under court that some person, whether known or unknown, has committed the offence. Okay. A police report forwarded by a police officer to magistrate under subsection 2 of subsection 1 of section 173. Fine. A report made by a police officer in case of which discloses after investigation the commission of non-cognizable offence. Okay. And all of the above except B relating to police officer. So option D is correct. Complaint ki definition, if you are well versed, you will easily answer this question. Then section 27 of Evidence Act is an exception to the rule stated in. It is exception to section 25, 26, both section 28. It is exception to both section 25 and 26. Right? आगे चलें. See, we are on question number 90. अभी तक जो भी क्वेश्चंस आए, we didn't tackle any question which is of difficult level, I can say. Case laws are there. Only one case law I can see that is of somehow not that landmark, but that is taught in the due course of that particular topic. Right? Then question number 90, under section 361 of IPC, the lawful guardian of the minor includes father, it includes parents, immediate relative, and option D, any person lawfully interested with the care or custody of minor. Option D is correct. Then question number 91, which of the following is incorrect about pleadings? Pleadings के बारे में पूछ रहा है. What does pleading includes? So it means a plain and a written statement. ये दोनों होते हैं. So it is correct, right? Then it contains a statement in a concise form of material facts on which the party pleading relies its claim and defense. So material facts होते हैं. It also contains evidence by which material fact are to be proved. No, it does not include or contain evidence. Option C is correct. Then question number 92. Which of the following is correct about admission under Indian Evidence Act? Admissions are conclusive proof of the matter admitted. Then admissions can only be made by the party to the proceeding. Admission may operate as estoppel and all of the above. Tell me, what is the correct answer? Correct पूछा है. So it is admission may operate as estoppel. Then question number 93, which of the following is correct about decree and judgment? So decree and judgment are the same. Is it the same? No, it is defined separately. Then CPC defines decree but not define judgment. No, both are defined. Decree includes any order or dismissal of default. So C is the correct. Right. Then next, accident in doing a lawful act may not be an offense if it has happened only accident or misfortune, if it has happened without any criminal intention or knowledge, if it has happened while doing a lawful act in a lawful manner by a lawful means and with proper care. See, on all these three options, malified intention is missing. See, in option A, accident, misfortune, option B, criminal intention is missing. So, option D is correct. Then question number 95, except for some exception there that may be there, which of the following agreements are void? So agreement in the state of trade, it is correct. In the state of legal proceeding, this is also correct. Agreement, the meaning of which is not certain or capable of being made certain, it is correct. Agreement without consideration is void. We have read this section, this line thoroughly, that agreement without consideration is void. So correct answer is option D. Then question number 96, the rarest of the rare case doctrine was propounded in the case of Bachchan Singh versus State of Punjab, guys. आप देखो केस लॉज बहुत सारे आए हैं, बट अगेन एंड अगेन आई एम एम्फसाइजिंग कि दोज आर ऑफ प्रोमिनेंट एंड लैंडमार्क. ऐसा नहीं है कि हमने कोई पहली बार सुना है. ठीक है, आगे चलते हैं. Question number 97. Which of the following kind of examination of witness is provided under section 137 of Evidence Act? 137 में हमें पता है examination in chief है, cross examination है, re-examination भी है. So all of the above is the correct option. Then 98. Which of the following is incorrect about agency under Indian Contract Act? An agent may be employed to do an act of the principal. That is correct, because agency forms the relationship between agent and the principal. Then option B, only such person may be employed as agent who has obtained the age of majority. Okay, fine. Then the authority of agent must be expressed in writing. Okay. And the no consideration is necessary to create an agency. So option C is incorrect. That is correct, but It is incorrect about the concept of agency, that the authority of agent must be expressed. It might be expressed or implied as well. Question number 98, option C is correct. Then question number 99, where a woman commits suicide within period of 7 years from the date of her marriage, and it is shown that soon before her death, her husband and other relatives of her husband had subjected to her cruelty in connection with any demand for dowry, then it is a case of dowry death. Simple. First of all, then we have two options, A and C. In C, they're just talking about presumption of dowry death as well as abetment to suicide. भाई suicide तो आया ही नहीं. So the correct answer is presumption for dowry death only. Right? And then last but not the least question for the today's paper, that is Mohri Bibi and Dharmoda's case. It is related basically to the capacity of minor. So whether a contract can be admitted to a minor or not. So this is decided in Mohri Bibi versus Dharmoda's case. So option A is correct. Guys, we are done with 100 questions. We have solved whole paper. Now, what's your take on this? I'm giving you 2 minutes to express what you guys have to say about this. I am looking in the comment section what you guys are writing down. Just let me know what scores you are getting. Because paper is easy. If we go to last year cutoff, the cutoff was around, in 2019, it was around 76. Let me write down here. 2019, it was around 76 to 78 for general or unreserved category. And prior to 2019, that was 2016, it was around same. It was around 75 to 77 for unreserved category. So what you guys say? What are your scores? Just let me know in the comment section. Yes, Seema, please tell your scores. Yes, guys, please tell me the scores. See, cutoff is based on, first of all, the number of participants, how many participants have attempted the paper, because the vacancy is around 138, which is far more than 2019. So participants have also increased, right? And the nature of paper, the difficulty level was quite easy. So around 82 to 85 out of 100 will be a decent score, or we can say cutoff for unreserved category. Right, guys? Any issue till here? 82 to 85, till 85 plus might it go, but 82 to 85 or more than 85, who the person who is scoring more than 85 will start preparing for mains, guys. Don't wait for the answers, don't wait for the results. Results might be out, but just start the preparation. Don't wait for the result, prelims result. If you are scoring above 85, then you have successfully succeeded for mains exam. And apart to this information, guys, I have one more celebratory information to you, that Lawsikho conducted a holistic test series for Jharkhand Judicial Prelims on, मैं उसमें बहुत inverted commas में आपको बता रहा हूँ, on the cost of ₹1 only. Very nominal cost. And we have gave around 15 mocks to you people. And out of those 15 mocks, I just got the data that 53 questions are from our test series, directly from our test series. Those are not derived, those are not like somehow taken from the any part of the question is taken in the actual paper. 53 questions are direct from our test series. And this data will increase because these 53 questions are from law section only. English and GK we have left as of now. But from 80 questions, we have more than 50 to 55 questions are asked from our test series only. So if you can see the impact of our test series, that is of nominal cost of rupees 1. And this big result is given by a test series. So what you more want from us? I just want to know some more guidance, a more dedicated or holistic test series for any other state. If you want to let us know, we will start that as well. But 50 to 55 questions directly coming from our test series is a big number. So if any one of you have any questions, any query pertaining to the question paper, cutoff, anything, just put it down in the comment section. I'm waiting for it. And then let's wrap up the session, because you guys have also like in the transit period, you are going to back to your home, or those whose center is apart from their state, so you might be having trains or flight to catch. So not taking much time of yours, we will be wrapping up the session within a few moments. I'm just waiting for letting me get the scores, what you have scored. आप scores बता दो, what scores you are facing, you are getting, so we will have an expected idea. जल्दी से बता दो आप मेरे को chats में बस. And then we will be wrapping up the session, and we will again meet for a new session regarding the mains test series, or for the mains preparation. If any one of you have want guidance regarding mains preparation, you can contact any of our team member for the mains oriented preparation as well. Okay, guys. Then all the best to all of you guys. Already you have done great by attempting the paper, by all the doing the hard work. You have won half battle by just giving this paper. So now making it a full battle, just relax and focus on the mains preparation as well. Right? Okay, guys, then. All the best once again. Bye.